In addition to needing an actus reus and mens rea, criminal liability also requires causation. Causation refers to the connection between a culpable act and the harmful effect it produces. As in tort law, causation has two components: actual cause and proximate cause. Under both the common law and the model penal code, actual cause is determined by a but-for analysis. But for the defendant's conduct, would the result have occurred? If there are multiple causes of a particular harm, the but-for test is applied to each one. If either act would have caused the harm on its own, then that act is considered an actual cause. Sometimes the defendant's act accelerates harm to the victim that is inevitable, but would have occurred later had the defendant not acted, as where a person kills someone who is on life support, for example. Typically, a defendant who accelerates inevitable harm to the victim is still held responsible as an actual cause. Once a defendant's role as the actual cause is confirmed, we then turn to the question of proximate cause. Under the common law, whether proximate cause exists depends on the outcome to two questions. 1. Was the harm reasonably foreseeable? And 2. Was it not too remote or inadvertent to fairly hold the defendant responsible? Another way of framing the analysis is to ask, was the victim's harm the natural and probable consequence of the defendant's conduct?